All right, we're going to conclude this PowerPoint on chapters 13 to 14. Resuming with slide number 74, we've been talking about different constitutional interpretations, the way Supreme Court justices interpret the Constitution, constitutional originalism, again, looking at what did it say, and then applying that to today. The living Constitution, what does it mean today? What do we want it to mean today? And then injecting preferences upon the interpretation, okay? You can review kind of the notes and the PowerPoint for that. I want to talk about the third aspect of constitutional interpretation, and that is reliance on foreign law and courts, okay? And there's an increasing tendency of the Supreme Court to begin to do this, and there's been a tendency to look at what is going on in Europe, what is European law saying, and then applying that to constitutional decision making. Again, is this controversial? Yeah, because you swear to uphold the U.S. Constitution, not the Constitution or laws of another country. Probably the case that began this, or began kind of hinting at this, was a 1958 case called Trop v. Dulles. And this was a case where an American soldier in World War II deserted in combat. He was in North Africa and he deserted in combat. And what typically happens when you desert in combat, in particular in World War II, you get shot. The military tribunal basically extended grace to him and said, listen, your punishment for deserting your unit in wartime is we're going to take away your citizenship. This actually made its way to the Supreme Court in the 1958 case. And basically the Supreme Court ruled in favor of the soldier and said that it's a violation of the soldier's constitutional right to be protected from cruel and unusual punishment. So in other words, the court thought that it is cruel and unusual punishment to take away this soldier's citizenship, which again, I personally think the guy got off kind of pretty well because he should have been shot. Okay, and what the court began to do is they began to say that the constitutional meaning is not precise, it's not static, it's not fixed, and that the court would begin to look at the Constitution and draw its meaning from the evolving standards of decency that mark the progress of a maturing society. So in other words, by implication, well, if America is not deemed mature by the Supreme Court, they might look at other countries that are, in their estimation, more mature on certain issues. Very, very interesting, very, very controversial. If you look at slide number 75, you can see some of the different cases where the court began to rely on foreign law in its decision making. In the case called Thompson versus Oklahoma, Justice Stevens held for a plurality of the court that imposing the death penalty on juveniles under the age of 16 violated the Eighth Amendment because it was inconsistent with the views of the international community. Again, that's a breathtaking shift in how the court begins to look at its adjudication. In other words, instead of looking at what we do as a country, they start looking outside. Okay, Atkins versus Virginia, a case where Justice Stevens said that they relied on the fact that within the world community, the imposition of the death penalty for crimes committed by mentally retarded offenders is overwhelmingly disapproved. And so he concluded that the execution of criminals who were mentally retarded constitutes cruel and unusual punishment and violates the Eighth Amendment. Again, looking to international law. In Lawrence versus Texas, again, this is the case that struck down all state laws that prohibited homosexual conduct. Justice Anthony Kennedy, again, let me just preface this by saying for the last decade or two, at least when he was on the court, he's been off the court now for a couple of years, but basically he would spend his summers when the court was off in Europe. And so many court watchers were suspicious of Kennedy in that thinking that, you know what, he got a lot of his ideas and a lot of his influence and from the Europeans in European law. And again, he spent 3 months of the year in Europe, and the concern was he was becoming more beholden to the European law system than he was the American constitutional system. So in Lawrence versus Texas, Kennedy basically felt that state laws prohibiting homosexual conduct was unconstitutional for a number of reasons, one of which was, he said, the values we share with a wider civilization. And he looked at the decisions of the European Court of Human Rights as justification for his conclusion that a Texas statute criminalizing deviant sexual intercourse between individuals violates due process and the right to privacy. Again, the logic that he used was the logic of the international community. Another case, Roper versus Simmons. This was a case where juveniles under 18 brutally murdered a woman, and the account was pretty brutal. I remember it from grad school, and it was one of those cases where it was obvious that this individual that committed this crime, again, the one individual was on trial, although there was a couple that were involved, should have most likely gotten the death penalty, or at least a severe punishment for this brutal treatment. But the court cited for this juvenile and said that it's a violation of this individual's constitutional right, again, the protection against cruel and unusual punishment under the 8th Amendment. Now, when the individual was tried, he was in his early 20s, he was not a juvenile, okay? So Justice Kennedy, again, just devoted a whole section of his opinion to the laws of other countries and international authorities, and he concluded that the 8th Amendment forbids imposition of the death penalty on offenders under the age of 18 when their crimes were committed. He acknowledged that the overwhelming weight of international opinion is against the juvenile death penalty. Citing briefs from the Human Rights Committee of the Bar of England and Wales and the European Union and members of the international community, he announced that our determination that the death penalty is disproportionate punishment for offenders under 18 finds confirmation in stark reality is that the United States is the only country in the world that continues to give sanction to the juvenile death penalty. And again, remember, the echoes of Trope v. Dulles, okay, is that basically the court is going to start looking at the evolving standards of decency that mark the progress of a mature society. So in other words, in the minds of Kennedy, America wasn't mature as the international community. Again, very controversial. I just want to conclude this chapter with I think a very prescient quote from Abraham Lincoln in his first inaugural address. In other words, he's responding to obviously the outbreak of the Civil War, but he's also responding to the Dred Scott v. Sanford decision, okay, which basically said that African Americans are not afforded rights under the Constitution of citizenship. And his concern was when the court becomes the eminent tribunal or becomes a dominant branch of government that trumps, pun intended or not intended, trumps the executive branch or the legislative branch, it can be very, very problematic. Again, remember the echoes of the Anti-Federalists that said, listen, we're supposed to have 3 co-equal branches of government that are supposed to be all equal. The court is all of a sudden becoming more powerful or can become more powerful. That's a problem. And that's exactly what Abraham Lincoln was warning about. So this is what he says. You see this on slides number 77 and 78. He said this in his first inaugural: I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court, nor do I deny that such decisions must be binding in any case upon the parties to a suit as the object of that suit, while they're also entitled to very high respect and consideration in all parallel cases by all other departments of the government. And while it is obviously possible that such decision may be erroneous in any given case, still, the evil effect following it being limited to that particular case, with the chance that it may be overruled and never become a precedent for other cases, can be better borne than could the evils of a different practice. In other words, he's concerned that when constitutional law decisions become binding on the nation and they move from the limited confines of that case to all other citizens and all other states, he said that could be a real problem. And then he concludes with this section: at the same time, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary litigation between parties, in personal actions and here's the punchline, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. In other words, he's warning that, listen, when the Supreme Court becomes the be-all, end-all, and you bypass democracy, you bypass lawmaking by elected representatives, you suddenly, the people are not their own rulers. They basically punted to 9 unelected judges to make decisions that are binding on, well, in our case now, about 330 million people. He said that's a very, very great danger. And again, that same logic was echoed by Antonin Scalia in his dissent in Obergefell v. Hodges, the gay marriage case. He said, listen, I don't have a big problem with gay marriage. What I really, really have a big problem with is who it is that rules me. And he said, listen, today's decision tells America that 9 unelected justices are basically ruling all of the rest of this country. And he said that is very, very dangerous. And I tend to echo those sentiments. In fact, this very quote, or the back end of this quote from Abraham Lincoln, we put in chapter 9 of our book, because again, we were trying to show Americans some of the dangers here with the Supreme Court and its ascendancy in our system. So conclude this section here, and hopefully this helps you as you prepare for some of your discussion posts. Talk to you soon. Stay safe, stay healthy, and I'll connect with you shortly. Take care.